SRIRAM's IAS, serving the nation since 1985. Ab offline, hoya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. This is the concept class. We have been running this series to help you in your upcoming prelims examination, and this will be class number 6. We have came up with a new concept to help you in your upcoming prelims examination. So let's begin our class with a new topic. Article number 14. What does article number 14 tells about is equality before law and equal protection of law. Now this has been extended to everybody. Okay, the first thing to understand about this article is this is the basis of equality in India. Right to equality is a big broad concept. Okay, article, if this is what article 14 is. Article 15, 16, 17 and 18, which comes into the bracket of right to equality, particularizes several things. For example, Article 15 says that there shall not be any kind of discrimination by state on the basis of religion, race, caste, sex and place of birth. Similarly, Article 16 tells about no discrimination on these grounds plus additionally 2 more grounds by the state in jobs. This is what Article 16 says. Article 17 and Article 18 at the same time, for 2 very important reasons, that Article 17 abolishes untouchability and Article 18 abolishes titles. So 17, 18, 16, 15, they are particularizing Article 14 into one or the other dimension. But Article 14 as a whole, this bigger Article 14, is covered under the concept of equality before law and equal protection of law. Both are written in article number 14. Now let us study this concept of equality before law and equal protection of law. Okay, now what is this equality before law? See, the definition of law we have already seen in the previous concept. Notification, order, bylaw, rules, regulation, customs, and to an extent several judgments of the Supreme Court have also called amendments as law, but it was finally decided in Keshwananda Bharati case that law does not mean amendment, but still any amendment brought by the parliament has to adhere to the basic structure doctrine of the constitution. Okay, so now if you see this law, there has to be equality in making the law. So there are 3 organs of government. If we see, executive, which executes the plans and the policies made by legislature. Okay, and if something wrong happens, there is a judiciary. Okay, there is a judiciary. In the working of all these organs of the government, there should be equality. Okay, the execution of the policies of the law made by the government, made by the parliament must not be done, shall not be done in such a way that it reflects inequality, where the implementation of a program is helping one section of the society and not the other section of the society. Class legislation is not allowed in India. We will study what is class legislation. Similarly, the policies made by the parliament must not at any cost be reflective of inequality, that it must not be discriminative against any section of the people on the basis of so many things. Religion is one dividing factor in India. Religion, race, caste, okay, a major dividing factor. Even on economic terms, that you have made something which favors the rich over the poor must not be done. So equality has to be maintained in all the rules and laws made by legislature, even by the state legislative assembly. Everybody who comes under the umbrella of the term state, the definition of state, we have seen this under article 12. We have studied this concept as well. We have studied the concept of law under article 13. Okay, so anything done by state through law should be equal, should reflect equality, should not reflect inequality. Okay, any decision taken by judiciary, it has wider implication. Sometimes it also has the effect of law. Sometimes judiciary makes the law. None of that must be reflective of inequality. It all must reflect the equality in India through law. Okay, I hope you have understood. Anybody who comes before the court must give equal treatment to all. There has to be political, social and economic inequality. That is what the article is all about. So equality before law is a brute concept, that everybody is equal in front of law. It is also said by many as a negative concept. Negative concept, we have brought this thing and bought this thing and borrowed this thing from United Kingdom. Now if you see the society of United Kingdom, it's a very equal society with very less dividing factors, and that is the reason over a period of time the evolution of the society in United Kingdom has only seen the rule of law in this manner, equality before law, that all shall be considered equal by law. All section of the society shall be equal by law. There are no castes there. The race problem is not there. The black and white, it's not there. The problem were proletariat and bourgeois classes. It was there for some time because of the coming of socialism and the fight between capitalism and socialism, but nothing historically are the basis in English society in the United Kingdom which can be called as a dividing factor in that country. And hence for a long period of time England has seen this concept equality before law as the only concept to treat equality, a brute concept. There is no section in their society which they have to uplift. Everybody, no matter what, must be considered equal in the eyes of law. That all the rules and regulations, laws and legislations, orders and by orders, notifications and customs, whichever are there, has to reflect this equality. It must not discriminate. It must not give some rights, more rights to some people or a class of people and give a little less to some other. The liabilities which you impose on the society has to be equal. That simply means if you are imposing a tax, it must be equal on all the people. If you are giving some right, it must be equal on all the people. But Indian society, if you see, is not like that. There are many differences and divides in Indian society. The caste system, the religious system, the women. There are many issues in India which has to be seen before implementing the concept of equality before law very brutally. That the brute implementation of equality before law would have helped in perpetual inequality in the Indian society. Now that was not the object of the constitution makers. There were several communities in India, several sections of people in India which needed upliftment, which needed help. So the law always has to come up with several provisions to help women, especially scheduled castes, scheduled tribes, educationally and historically backward classes, and economically weaker sections. Now when laws are made, they can make special provision for these classes. Now where is equality if you make special provision for these classes? So I hope you have understood it now. Equality before law means that everybody is equal in front of law. The liabilities which are imposed, the rights which are given has to be implemented equally among all the people. But given the Indian society, there are differences. There are sections of society which makes it unequal. And if you try to implement this principle of equality before law, this principle of equality in a brute manner, the people who were educationally and socially backward, who were not in the mainstream because they were living in the tribal area, or several castes which are considered as scheduled caste and were considered untouchables and has seen many discrimination in the past from a very, very long time, they all will face perpetual inequality. These communities will never be able to come up with the people, mainstream people. Now in order to bring those people in the mainstream, something has to be done. The law, rules, regulations, orders, by orders, everything, even amendment has to be done in such a way that these sections of the society are supported. Special provisions can be made for these people, which is very much important in a society like India. Then only, for example, during independence, some people have started at this level, few people have started at this level, but there were few who have started at this level. Now you implement the brute equality concept, equality before law. That means this fellow is equal to this fellow is equal to this fellow. That simply means this section of people is equal to this section of people is equal to this section of people. Now, do you really think section 3 people would ever be able to match section 1 people at all? In all the walks of life, it will be very, very difficult. So what instead we have done is something else. What we have done is we have created a platform. For section 1 was here, there was no help by the law because they had already grown. This other section, this section number 2 needs to be brought up, and that is the reason section number 2 was helped. This is the help. Similarly, the help is bigger for the third section of people. This is the help. It's bigger help. This is section number 3. So these helps are provided. Special provisions are made. This is called as affirmative action, and this is the basis of reservations in India. I hope you have understood. And once you have understood, let us go to the next slide of what is called as equal protection of law. So equality before law, equal protection of law. What does it mean? Article 14, the text of it, if you see, it involves both. The state shall not discriminate anybody on the basis of equal protection of law and equality before law. Both must be maintained. What is equal protection of law? This is equal protection of law. That several sections of the society, which we have already seen and written here, these sections of the society need some help, some sort of affirmative action, because we have to undo the wrongs done by ourselves or our forefathers. So in order to undo the wrongs done by the past, we have to bring in something, some provision in the constitution to help people which were not in the mainstream society to grow, to become more equal, to make the Indian society and polity more equal, to bring the section of people which were historically and educationally backward to the level of the mainstream society, to bring women to the mainstream society, to bring the scheduled caste and the scheduled tribe into the mainstream society and equal to the other section, which we in general language call the general category section. Okay, I hope you have understood this concept, that some help was required, and that help was reservation. There are other helps which are also done. A special provision under Article 15 can be made for a few sections of the society, for women, for scheduled caste, for scheduled tribes, for OBC, and now for economically weaker sections as well. Okay, why this help is done? Now this help is called as affirmative action. And one more thing, ये जो help है, ये कोई एहसान नहीं है उन पर, ये उनका हक है. This is very important to understand. This help is not some kind of ehsan. That is their right. Okay, it has to be done. So this affirmative action is to make provision for the society, for several sections of the society, in order to bring them to the level of equality, so that the equality as a whole can be maintained in the Indian society, in Indian polity and Indian economy. Okay, the contribution of those sections have to be equal to the contribution of the general section. Okay, So equal protection of law is that the law protects everybody equally. That simply means wherever more help is required, law is going to help them a little bit more. It's a positive concept. It's a positive concept. We have applied this and borrowed this from the United States of America, where there is a huge division and divide between the blacks and the whites. Now, in order to make the blacks equal in the society, several affirmative actions were taken to help them come to the mainstream society. Several laws were passed, regulations were passed. Okay, they were given citizenship of that country. That was done in order to bring equality in the society. Because if only brute equality was to be implemented, just like Britain, the blacks in America would never have been able to come to the level of whites. In order to bring the blacks to the level of white, several constitutional provisions, several provision by the law was very, very important. And that is called as affirmative action. And the whole concept is equal protection of law. That the law is going to protect everybody equally. Wherever help is required, law will intervene to ensure the help. Law will intervene to make special provision wherever required. And that will not be against the concept of equality. That will itself be called as equality. No one can come up and say, when you make special provision or bring affirmative actions, that is hurting the concept of equality. No, because if this is not done, there will be perpetual inequality. Those sections who were historically backward will always remain backward, will never be able to grow to this level. Okay. Now, in order to bring them to this level, help, provision, special provision, everything is required. And that is their right. That is their right. Okay. Constitutional guarantee. Now, reasonable classification doctrine, another concept. What is reasonable classification? So we have to understand what is classification. We have already done this. See here. This is what is called classification. That we have classified the sections of people who are belonging to scheduled caste, scheduled tribes, other backward classes, economically weaker sections. All these classifications are done. Different sections are made in order to give them some kind of benefit, in order to help them grow in a more faster manner than the rest of the society. Some classification needs to be done. Now there has to be some basis of that classification, and the basis has to be reasonable and objective. Reasonable classification, the objective of that classification, the basis of that classification has to be reasonable and has to be objective. Now, reasonable classification doctrine as a whole tells that there has to be nexus. There has to be some kind of nexus between the object to be achieved and the classification done. Okay, the object which has to be achieved and the classification done, there has to be a nexus. That the object was to achieve equality in the society, the object was to give a special provision to the section of a society. Okay, it's a good object, but that object must match with the classification done. That the object is to, let's say, for example, uplift the backward sections of the society. Uplift backward sections of the society, and for that several provisions were made to induct the children of the backward classes without any cost without any cost in private educational institution. Let's say this is what the object was all about. Okay, then the classification would be who will be the member of this section. Now this is the object to be achieved, that their children, the backward class children, were to study free of cost in the private institutions, private educational institutions, for the betterment of the backward classes, for the upliftment of the backward classes in India. Good enough, it's a good objective, but then the classification has to be done, that who will constitute and who will be the backward classes. Now these backward classes, when the classification is done, it should be reasonable and should be objective. Now if you tell any person of the general category who with time has become poor to be included in the backward classes, that will not be a objective and reasonable classification. Okay, because a poor person is a different thing and a backward class person is a very different thing. Okay, here the object is to give free education to the children of the backward classes. So just because a person is poor belonging to a general category, we cannot put the person into the list of the backward classes, because the person belongs to general category. He has not been the victim of social, educational and historical backwardness in India. I hope you have understood the object and the classification. There has to be a nexus between them. Okay, I hope you have understood this. Now coming to the next slide, class legislation. So when you make this classification, and if it is not done on the basis of reasonableness, on the basis of objectivity, you may tend to create class legislation. That simply means a kind of legislation, a kind of law which either puts liabilities on one section of people, or give unnecessary or extra rights to one section of people. Okay, this is what is class legislation, that you are creating a class to impose liability on them or to give unnecessary rights to them. This is what is class legislation. For example, what if government brings a law which only helps the top 1% people of India, economically empowered people, top 1% net worth people in India? This is class legislation, because any legislation must help everybody. Okay, so I hope you have understood this, and there is nothing more to tell in this class legislation. The only thing is, whatever law, rule, regulation, legislation the parliament is making, any policy, any ordinance the government is bringing, that must be applied equally to all, until and unless that is a special provision for some backward class. And for that also, classification has to be done on a reasonable ground. If unnecessary liabilities are imposed on a class of people or on a section of people, unnecessary rights are given, favoritism is given to a class of people, then that will be called as class legislation. Now this is not allowed in an equal society which promotes rule of law, which promotes equality. Class legislation is prohibited. So it is the job of judiciary to stop the executive, especially the legislature, in making class legislations. Okay, I hope you have understood. We will come up with next topic in the next class. Till that time, bye bye and Jai Hind.